I did get a note from two persons that they are going to be late, but we got a really small number today, but we're gonna begin. I'll start with a ton of apologies. I've had this really challenging week. It's not feeling well in the first place. I think my traveling last week took a toll on me. So while I have gone through your assignments 3 and 4, and I must say that persons did put a bit of effort into those assignments, and really nice to see. I've yet to fully grade them and return the grades to you, but don't worry about that. I did prepare, as I intended to send you earlier, I did prepare a quiz based on chapter 5. I think it's chapter 5. Was that the last thing we did? Yeah, chapter 5, or lesson 5. I prepared a quiz for that, and that is scheduled to be available to you. I'll talk a bit about that again when the others get here. But that's scheduled to be available to you on, I think it's at 12:11 or something. So it's right after the class. It's a half hour that you have to do the quiz. It's the same format as the last one you did. So it's multiple choice. Well, there are two types of questions. They're multiple choices. So they're questions that are true and false. You select one or select the other. And then the others are all checkbox questions. So you get asked a question, you have to check the appropriate box or boxes under it. Those are the questions you have. There are 20 questions. Don't be fooled by the small number. They cover the chapter, and you have to do a little bit of thinking to make sure that you answer them correctly. There's certainly, you have half an hour. You don't have to begin them actually at 12:11 today. You can start them anytime, but they must be turned in, I think, by midnight on Tuesday night. So if you're gonna do them, you would certainly have to start the latest at 11:30 on Tuesday night, because they must be turned in whenever, but you can do them at any time, do the quiz at any time before that, obviously. You just have 30 minutes. So you chisel out a 30-minute spot for yourself and do it. As with all the quizzes you're gonna get, you have to do all the questions, or the quiz will consider itself not done and you won't be able to submit it. And you have to get it done within the allotted time. So it's for you to do at your pleasure at home. I would advise you to be careful about trying to do it as a open book thing. I'll tell you why. Because you only have 30 minutes, and the minute you open a book, you'd be shocked at how much time you burn looking at the simplest thing. If you are one of those people who are really good at this stuff and you get the quiz done very quickly, then you have the facility to maybe check stuff by going through sources. But I'll tell you, you don't want to start every question by trying to rummage through material to try and answer the question. You will never get finished. Okay, so before we start discussing this important chapter, which wraps around with other things that we've done actually, because this talks about the lease, and the lease agreement is the place where we document, but let me get somebody else to say this. So I'm gonna start with Kevin. Kevin, what is the lease and what is the point of it?
Well, a lease is a contractual agreement between two parties regards to tenancy and rental, wherein both parties make assertions or promises to each other. And also it creates a legal commitment and a legally enforceable commitment on both parties. And it has a strength in that it can be, presented to a court in terms of, looking at breaches. But it's really the embodiment of promises between both parties, and also it calculates the stipulations, the owners stipulations regards to the property ownership, the property treatment, how the property is to be maintained, managed in the course of the period of time of the tenancy. And also by signing it, the tenant agrees to abide by those promises and those commitments. So it's really a contract between two parties. That has a strength of law.
Very good. And one of the things that I'd like to introduce is the question that and the book talks about a little bit. Can you do a lease by handshake, Kevin?
I mean, you could do it, but then again, I mean,
you can, right?
It's preferable, like most contracts, you want it to be in writing for it to be enforceable, because when you have a handshake, you can't really take a handshake to court. The court will just have to abide by good faith, but it should be in writing. Like any land agreement, it should be in writing, but it could be by a handshake.
Right. So if you have a tenant that's going to be renting a property for whatever the length of time, because one of the things to notice about the lease, although lease is normally thought of as a long-term document, some of the other names for leases are rental agreement. You could rent something to someone for a day. Yeah, that's something like booking a hotel room, but you can rent something to someone for a day, for an hour. It doesn't matter. It's allowing someone to use their property under certain stipulations over a period of time for an amount. It's really what a lease is. So that time can be anything from 10 minutes. I can lease you my pen for 10 minutes if I want. I really can. To 100 years. One of the most famous leases we have in the Bahamas is that Freeport is leased to this place, this company called the Grand Bahama Port Authority. For those who are not aware, that's a lease agreement. Freeport is leased to that company, and it's for 100 years or 199 years or so. It's for a long time. And it's been the cause of much angst, because you've had governments come and go who would wish that they didn't have that lease so they could do with Freeport what they want. But the Grand Bahama Port Authority has a lease, and governments have come and tried to change stipulations in the lease. But what is one of the problems you run into when time passes and you realize that, hey, I wish we didn't agree this particular thing. I wish I didn't agree to allow my tenant to paint the place, because they keep painting it purple and black and stuff like that. Now I want to be able to tell them, look, I want to take that out of the lease. Can somebody speak to why that becomes a challenge? Because that's one of the challenges they have with the Port Authority. Brittany, why do you think? Oh, Marjorie is here. Brittany, why do you think that's a challenge? If you just have a stipulation and time passes on, you realize, you know what, this thing is old and it's causing us problems and so forth and so on. As the property owner, it really makes sense for me to change this particular thing in the lease, but we only halfway through the lease. What are some of the issues that you may have? We're trying to do that.
I think now you would be stuck with an agreement that you no longer wish to, I guess, uphold with your client.
Yeah, and I mean, to be honest with you, you can have some really, really small things that can cause a lot of pain. Small things that you agreed to at one point, that everybody was fine with at one point. But times have moved on and things have changed a little bit. And this little thing, it just feels like a sticking point. And sometimes you think, man, this is a simple thing. We should be able to change this. But you'd find that sometimes that's a difficult thing to do.
Is that is that something that?
Marjorie and Blair has something to say.
Okay, good morning, everybody. Thank you so much. Thank you. Ian, would that be something that the special consideration would be used for? Because that way you can actually make that change as a property manager or an owner, the same way that a tenant would request a special consideration. So that goes both ways, even though it's a contract. It's not like you're changing the entire contract, you're just changing a portion of it. And according to our text, it's something that you would make note of, that it's not a change to the contract, it's just an amendment with the special consideration. Would that be something that we could do in that instance? With
Well,
the pay?
obviously you can make a change. So the quick and dirty answer is yes, you can make a change, but that will have to be mutually done. Now, one of the things that you may be alluding to is that you can put in your original contract that the parties agree that non-material changes to this contract are allowed within this particular period, given that both parties agree. And those changes can be made without having to terminate and renew the contract. Because essentially, when you're going to try and change a contract, most lawyers are going to say, changing a contract is not a thing. You're going to have to renegotiate the contract. We're talking in this country this week about union negotiations a lot.
Right.
And what you find about union negotiations is that whatever was agreed and signed on paper, for instance, even if one party wants to do something that's of benefit to the parties, and that's not in the agreement, the other party is likely to say, you can't do that because it's not in the agreement. And you can't add it to the agreement ad hoc. We're gonna have to negotiate that. Because many agreements allow a space for negotiation, but you certainly can't say, I'm gonna add something. And in many instances, agreements are saying, if you're gonna change something, you're gonna open the door to everything being changed, or you have to open the door to everything being changed.
That's true.
Ian, in terms of those contracts, it seems as if like the Bible states, everything is line by line and precept by precept. So if you change one item in the contract, you pretty much disallowing or disqualifying the whole contract. So you really have to exit that contract and enter into a new contract, unless you have, as you said, that out clause where you're saying that non-material items can be, is open to negotiation. But even then, non-material, I mean, who's to say what is material to me?
Yeah, thank you. That's the problem. Unless you specify, if you're gonna get general like that, Kevin's point is very valid. Because even if you put in a special condition that says, a non-material, then you still get into these arguments, because what's non-material to me today may not be non-material to me tomorrow, and God knows what it is to you. So unless you specify, for instance, that a special condition, like say you have a condition in your lease that your tenant cannot have more than, okay, that you're renting them a 2,000 square foot area, and you're saying that the tenant cannot have guests of more than 20 persons at any one time on the premises. And the tenant agrees to that. And as it turns out, you find out that 20 persons is becoming quite of a problem, and you'd like the number to be 10. Now, if you had put into that clause that the tenant and the landlord agree that that number, the 20, can be changed to a lesser number upon agreement of the landlord and tenant. If you put that in at any time, then the landlord and tenant are in a position where they can agree a lesser number, because you specifically say a lesser number. In fact, you can say a lesser number of no less than 5. And you can get very particular in a clause like that. You may be able to then, because the contract gives you a leeway to make some changes to certain numbers. In fact, technically, you don't even have to change the contract. You just have to sign a little note that says reference to clause so-and-so. We're now agreeing to change the number from 20 to 10. But trying to change something in the contract, as Kevin says, really puts you in a position where you make the contract null and void, and you're gonna have to have a new contract. Which brings us to an important point. And I'm gonna ask somebody to weigh in on this. In the Bahamas, we tend to leave leases, because the lease is a contract, up to lawyers. We tend to do that. And I'm going to propose to you that as property managers, one of the things that you really want to focus on is understanding, knowing how to make an impact on what is in a lease, because I'm going to put myself out on a limb and tell you that lawyers do not know what they're doing. In the main, what they tend to do is they grab a form, a document that's a lease, that is a standard lease form. They change the date, they change the name of the lessee, the leasee, the lessor. They change the considerations, the square footage, the location of the place. They change these things, and the rest of the document is the same. Now, could someone tell me from a property management perspective, as wonderful as that document is, and it's a standard lease document, what are the cons of a document like that? What are the possible disadvantages of a document like that a lawyer has prepared without any consideration from an expert like a property manager?
I'm thinking that, good morning, everyone. I'm thinking that the lawyer can miss out on including some clauses that can help, that can protect, I should say, you as the property manager with regards to the relationship between the property manager and the property owner. So that could be a disadvantage. They could miss out on some special details or clauses, like I said, that can cause you to be at a disadvantage if anything happens while you serve as the property manager.
Okay, anybody else?
It could be lazy, right? Because the lawyer is saying that these are all the issues or the things which should be covered in the lease. So it doesn't give you the leeway to really think and make it specific to you. Because if you're using a general template and you're applying that to yourself, you're not factoring in those specific things which relate to you and the protections which they to you. So it's like a quick way out or a fast food meal, as opposed to it being a well thought out agreement that applies specifically to you and the tenant.
Yeah, I mean, and Kevin says a quick way out, but it's actually a standard way out. Most persons are doing a lease, they hit up their lawyer friend and say, hey, we need a lease done. And in fact, one of the advices that we get out of this class is that you probably don't want to have a lease completed without having an attorney's eye or involvement with it. However, the important thing is for a property manager is that you want to have an impact on the lease, because the non-property manager professional, whether they be a real estate agent or a lawyer or whatever, is not going to be thinking about the sorts of things you ought to be thinking about. When you think about the stuff that you're looking at in this course, you want your lease to cover your specific circumstances. And it's not, somebody mentioned a boilerplate approach. That is never going to happen if you are just pulling out a boilerplate lease. It will cover most of your circumstances. And in fact, it may have things in that in a standard lease that will disadvantage your particular circumstance. So you want to be able to bring to the table that, look, these are the things in my relationship with this tenant or with this property that the lease needs to speak to clearly. And then the lawyer can put that in legalese, but you are the one who needs to understand the stuff that you want to have covered in the lease without even looking at the standard lease. All right, so one of the things that I think it's almost at the very beginning of the chapter, it has a whole list of things, and I'm going to leave you on your own, for instance, to really try and memorize that list. That you want to be sure when you pick up a lease document that these things are represented, the obvious things. The lease must name the parties involved, and it must be specific, because I have seen instances where somebody is named on a lease, John Brown, and say John Brown is the tenant, and there is a problem, and the lease does not clearly enough identify who John Brown is, and John Brown claims that wasn't me. That has actually happened, because the name is common, and you don't, even if the name wasn't common, you don't clearly say John Alexander Brown of such and such a place. And some people go as far as to pin down your birthday and pin down other marks of identification, so that you cannot then come back and say, yeah, that's my name, but that wasn't me. You need to be able to specify who you're dealing with on both sides of the divide. Who's the one leasing the property specifically? What's their address? Something that says something that when you go to court, you do not run up against the argument that has been made in court before. Judge, Your Honor, there's no evidence that the person named on this lease is my client. We don't have a case to answer because we don't know who this is. It ain't him. So you do want to make sure things like the names, the addresses, the exact size of the place that you're leasing, where it's located, identifications, or identifying the person, all of that, as much identification as you can about the person leasing, the person doing the tenant, as much information about the property as possible. And this is where lawyers tend to get very boxed in because they have a specific way of describing the property. And what you want to do is be as descriptive as possible without going overboard, because sometimes you even have to add an appendix to the lease describing all of the furniture, for instance, where you say, I'm leasing this property to person A along with the furniture, and they're responsible for the furniture. It doesn't help you to say that if at the end of the lease, you walk in and say half the furniture is missing. How do we know that? The lease doesn't say what the furniture was. So you can cover that by saying the furniture listed in Appendix A. And in Appendix A, you list the furniture, and you just can't say table, chair, whatever. You can say table. And in fact, the way we talked about it in this course is that with modern technology, you take pictures of stuff and you can get very detailed. You can say the table, if it's manufactured by someone, you put the manufacturer's date. You can put the value, whatever you want to put in an appendix on every item of furniture and the condition and so forth and so on, and have it as an appendix to your lease, so that if there's a dispute, the person can say, yeah, we agreed that I was going to not be renting furniture, but the furniture that my landlord is talking about was not there. But if an attachment is with the thing, they can't run that argument. Let's talk a little bit about the security deposit, because that's been talked about throughout the text. But I guess, Georgia, what is your view on what the security deposit is, why we have it? Do you use it in every instance where you're lending and leasing to someone? And how do you set something called a security deposit? What are your views on that?
My view, good morning, everyone. Yes, we should have a security deposit. And the security deposit is just as it says, for security purposes for the leaseor, in terms of any damages or replacements or so, that they would already be assured that they have that kind of insurance in place. And by law, it should be refundable, because to put a non-refundable one, they say, is illegal. So I believe everybody should have a security deposit in leasing a place.
Okay, so as a property manager, do you just mentioned that you believe everyone should have a security deposit. Do you see any situation where you would rent something to someone and not require a security deposit? Anybody can answer that.
I've never come across any. Even the hotels require a deposit incidental fees.
Okay.
So, can I?
Blair, yeah.
I mean, it wasn't specifically, it wasn't pertaining to anything with land, but I would have rented something where they didn't require a security deposit. I can say, namely, a vehicle. Because when you're renting from your family, sometimes they would, say, well, you don't have to pay the security deposit. So in certain instances, I won't say anything pertaining to rent apartments or renting land or something or anything of that sort. But there have been instances that I experienced where the person didn't require me to pay the security deposit.
So you seem to be indicating that in those instances was an instance where the other party is saying, look, and I'm going to use the word loosely, because of my relationship with
Yes.
you, I don't care if you bind this car up, that I have some recourse to fix the bang up.
No,
I don't
think they think about the bang up. They think about, oh, she's in good faith.
yes, they think about, they
Not
look at,
thinking of the consequence, though, which does
yeah,
happen.
they look at, I can say this, they look
And
at
then
like,
comes the
oh,
family
well,
dispute.
they would, they would say, well, you're a good person or you're good people. I've heard that before. So I won't let you pay the security deposit. I think they look at amicable ties or if you're family. I've experienced that a lot. I could attest that.
So the idea here is that the security deposit, while it needs to exist, it can actually be zero. It can actually be something that's of no huge consequence. And this is something that, again, as property managers, you want to bear in mind. And as business people, you want to bear in mind. We talked about this before. If you have a fee that should be charged to someone and you're gonna give the thing to them for free, that fee should be listed as zero. But you shouldn't get rid of the fee. Let me say that again. If you have a business fee that should be charged to someone, and there's a reason why you want to waive it, you shouldn't get rid of the fee. You should show the fee as zero. In fact, the best way in my mind is to show what the fee is. So if the deposit for something is normally $2,000, but you are going to waive it, I would put it on my bill. The deposit is $2,000. However, deposit waiver is minus $2,000. Deposit due is $0. Everybody got that? So
you're saying that once the security deposit is waived, make sure that it's in writing.
Right. Okay. Make sure you say make sure the person sees the value of what is being waived. If you're going to do something for someone for free, the free should have a value. That's a good business practice. The free should have a value. And what some people do is, especially when they're going to do something for someone for free, if you're going to do it for free, then it gives you an opportunity, because sometimes the actual charge is below the value of the thing. So if you're going to waive it, this is the opportunity to say, you know what, the value of this thing that I'm waiving is actually not $2,000, it's actually $4,000. So I'm putting $4,000 and I'm waiving the $4,000 and you don't have to pay nothing, but that is being evidenced on your billing or evidenced on your invoicing, so that you understand what free means. Free means that something you should have paid $4,000 for, you're paying nothing for. That's what free means. Free doesn't mean that the thing wasn't worth nothing and I gave it to you. Anyone with any views on that sort of principle?
I in the morning, everybody. In addition to what Ian said, I agree with what he's saying and just how Georgia and Blair indicated that scenario. I think it may also be beneficial to, and not for other people's business, but for your own. If you want to consider giving access to property or access to, well, property can encompass anything. Access is something that you want to waive because of relationship. It may also be a very good thing to, as Ian indicated, show the value of what the deposit is or whatever it is that you would have waived. However, you can also indicate on that document or that contract where they pay for the usage, you can also indicate the security deposit or whatever is waived. You can say that this is waived. However, if this is returned with significant levels of damage, that the person is still liable for repairs or replacements, etc. Because at the end of the day, like Georgia says, there now comes the family feud or the friend feud or whatever. So at some point, you still have to put some things in writing to always protect yourself, because when row day comes, you're like, no, they lent it to me. They didn't tell me I had to fix nothing. It wasn't my fault. It was an accident, blah, 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 blah. But all those good gestures or good intentions don't replace or repair your assets.
I agree. I wholeheartedly agree.
Okay, Kevin?
Oh, yeah, but no, and then basically what you're saying, right? What you're saying is that, I mean, what I'm hearing is persons allowing persons to access their property with a security deposit. And if you're a property manager and you allow a tenant to occupy a premise without security deposit, you're exposed to malpractice. Because as Odessa said, if the tenant does damage to your property, there's no insurance and no surety that you can draw upon, which is the deposit. So if you are practicing that as a property manager, you are exposed to malpractice, and I think the owner can sue you for the deposit because that.
Yeah.
Yeah, and Kevin, I think most people do that. Well, some people will do it with other people's things, but I think most people, when they do it, it may be their own company and their own asset. So, but you are correct. If it's somebody else's, you should actually think not to do it at all.
Right, right. So that's an interesting conversation. It's something that as you progress in your businesses, you want to really think about when you start to make exceptions to fees and to things like security deposits and so forth and so on. It can be a slippery slope, and it can leave you open to quite some things. And then the next thing in talking about security deposit, really, how do you set it? What is this amount that is security deposit? And there's some standard things that in leases, and some people will argue, that stuff ain't enough. And some people argue that it's too much. But as a rule of thumb, as a property manager, how do you go about determining what is a rational security deposit that you're gonna throw into a lease? Cleophas,
Sorry.
sorry, Odessa, you go ahead.
I don't know how it's usually determined, but I've noticed that over the years.
I want you to use your wonderful intuition and common sense here.
Okay, I've over the years I've seen where it has been evolving. I remember it used to be like almost a standard $400. Like say if you were going to rent an apartment, a standard $400 or $500. But now it seems like a lot of people actually use 1 month's rent as the calculator. However, I feel as though there is almost no way that you can set a security deposit that's going to cover all damages that is going to happen or could possibly happen. So I think the 1 month rent or 1 day's rent, depending on what the rental thing is, whether it's daily, weekly, monthly, etc., would be feasible.
Yeah, fine. Yeah, that's a good idea. What some people do, by the way, is if you're gonna, for instance, particularly if you're renting out a furnished property, so we're talking about residential or even commercial. What some people do is to make sure that the level of the security deposit can cover we talk about insurance later on in this course, but can cover the insurance they're going to take out on damages to property. Because most sensible persons are not going to say, well, hey, I'm going to hope there is no damage. And if there's a damage, I'm going to hope it's less than the security deposit and so forth and so on. They're going to assume that it's possible there's going to be a damage, and I'm going to bite the bullet and take out $100,000 worth of insurance or whatever the insurance is, coverage for the furniture for damage coverage. And the premium for that may be X dollars, and you want to make sure that the security deposit covers the X dollars. But you have to remember, the security deposit cannot be so onerous that you cannot return it to the tenant. In fact, in many jurisdictions, you have to ensure that the security deposit is never used. You can't say, well, I'm going to use this, and when the person's leaving, I'm going to find it and give it back to them. No, in many jurisdictions, you literally have to put that aside and make sure that it's there when the tenant leaves.
Yeah, so that all what you're saying is correct with the what about the residential tourism industry, for example? You know, we have like these hybrid properties where persons lease out their home. So what I understand what happens is the security deposit that's charged is based on the value of the actual property itself. So
Right.
doing a 1 month would be in keeping with obviously the kind of rent that that person is paying. So for example, a higher end property, if they're paying like 5,000 a night, then that's what would be the deposit for the property would be 5,000 in addition to whatever their night stays are. And that definitely makes sure that whatever's in there that's worth that kind of money. And as you said, Ian, should it go over, then that's where I suppose the insurance would kick in. But it definitely gives them the buffer that if there's something in there, a vase or something that a child breaks and it's a $5,000 value, well, that would go towards repairing that item. And
Yeah.
that's how I've seen it with many of the properties that I've been a part of.
And today, when you're talking about renting, you're running into all state. They're getting the rental market is becoming a bit like banks now. It used to be simple, get a security deposit, and that was it. Now people are talking about this tax and that tax and this
Right.
fee and the other fee and all these things that are coming out of left field that actually amount to quite a bit. It's almost like when you buy a plane ticket, it's $400, and when you buy the ticket, they say that the taxes and fees are $400. So you're getting a bit of that in the property market as well, where people are getting creative with all sorts of fees and charges up front that you pay before you can even move in. There's application fees and all sorts of things. Okay, so want to move on a little bit. By the way, I want to stress again that if you as you read through the material that we're preparing for these sessions, that the burning points that you have, I hope to get them ahead of the class so we can focus on some of those points. So anyone with any questions or comments up to this point, I want to move on to sort of looking at the stuff that's on page 106, and I'm going to leave you to look at that. But any other points before we move on?
Good evening.
Cleophas?
Hello?
Yeah, we can hear you.
Okay. Going back to the part where we were speaking about waivers of fees and stuff like that. I think you were saying, or you were using the word free. I don't like to use that word when it comes to those type of situations, because it's to me, it's not free. It's just that I'm absorbing the cost.
Yeah, zero charge.
Yeah, I'm not charging you, but someone or something has to absorb the cost. So in a situation like she said, the rental car, if I don't charge you a security deposit, but then you go out and you hit my bumper, now I have to fix that bumper and I will have to absorb the charge because I didn't charge you the security deposit that is synced with the lease agreement that, hey, I will keep your security deposit if you hit my bumper. So now to avoid that whole back and forward, I now absorb that charge. So that's one thing I do. Like you say, I do reflect it on receipts that, hey, if the security deposit is 250, then I'll put like either I'll say discount or waive. And like you say, show the value, but I definitely wouldn't put free. And then with what we were talking about with the agreement, I don't know how they do it now with the Airbnb, like because it's so quick in and out. I don't know how security deposits those be, but I know like with long-term rentals, well, maybe not long-term, like you say, it could be a month or a few months, but a lot of the security deposits for those usually be 1 month rent. I've heard people say it because a lot of times um, that last month, because people do first, last, and security deposit, but a lot of times in the last month is when you find a lot of issues that weren't reported during the stay of the tenants, and then that's when you have a lot of the issues and a lot of the repairs that need to be done. So a lot of people like to put a month worth of pay, I guess, or rent, just to cover those type of expenses at the end.
Yeah. And it's a slippery slope to believe that you can, especially if you're a bad tenant, that you can in all instances have enough of a security deposit to cover the problems that you may end up with, which is why you should at some point, in particular, if you have a very valuable property, you want to start talking about insurance at some point, because you can run into some bills that ain't no security deposit can help you with. And you need to have some other form of being able to cover those things, because you don't want to dip into your pocket or spend money suing the person and wait. Because some things, for instance, if you have a rental property, your property is not useful unless it's in a state where you can rent it. And even if you have to turn around and chase someone for some money, whether that's suing them or whatever it takes, that's going to take time. And in the meantime, you need to have the resources to fix the place and get it back on the rental market if that's the problem you've run into. Okay, so let's talk a little bit about, and I hope you really go back and read through 106. By the way, let me go back to what I mentioned at the beginning of class, because not everyone was here. At about 12:11, a quiz is going to be available to you. You have 30 minutes to do the quiz. You can begin the quiz at any time up until, I would advise, 11:30 on Tuesday night, because it is due by midnight on Tuesday night. So you can chisel out a half an hour anytime between 12 o'clock today and midnight on, well, not midnight, 11:30 on Tuesday night, and go through that and do that quiz on your own.
And you said the quiz is on chapter 5, not chapter 6.
Chapter 5, that's right.
Oh,
Chapter
yes,
5. Pardon me?
I thought it was chapter 6, Lord. Okay.
Yeah, that quiz is on chapter 5.
Okay.
All right, so we want to just have a look at some legislation, and one of the things that you get out of this chapter is at the very back, there's a long list of legislation that I really want you folks to have a look at. This is a long list, so you obviously not going to be able to look at this in a minute. But over the course of your career, especially the ones that are asterisked, you want to, at the very minimum, know what these laws are about. What do they say? What are they talking about? So you want to have a look at at what we call the property manager's bucket list, and the ones that are asterisk, like the Division Walls and Fences Act and these things that you probably never heard about before, you want to get acquainted with them. Because again, we tend to have a fairly lazy approach to our learning. And we put one or two legislations under our belt and we don't realize that other things exist. For instance, there's a legislation that talks about the rights and responsibilities of someone who has a dock on their property. And you can find if you don't, it's a very short act, but if you don't know about that act or know what it says, you might be contravening the law in a relationship or the way you're managing a property that has a dock or has a small pier to pull a boat up to. So you need to, the Fences and Walls Act sounds quite innocuous, but you need to find out what does that say. And a lot of these acts are very small, and you make your own little journal of some of the main points that these acts are talking about. So let's talk about the huge legislation, the Industrial Encouragements Act, the Vacation Plan and Time Sharing Act, the Tariff Act, and so forth and so on, the City of Nassau Revitalization Act, the Family Island Development Encouragement Act. I'm going to start with the last one. The Family Island Development and Encouragement Act is a huge act that you need to understand as a property manager. Because I mean, let me get you involved in that. Anybody can tell the rest of us in a nutshell what that act does and why it's important to a property manager. Now, you guys should have somebody gonna pick on somebody.
Okay, so this one, well, I believe this is something I had a discussion with my sisters yesterday concerning it relates to concessions that you can bring in to start businesses on the Southern Family Islands. Some islands are exempted that you would think is a Southern island, but it's really to promote building of homes. It's to promote building of, I guess, small rentals and I guess just startup businesses. So you may find that a lot of people may be interested in, even if they're not from those islands, they may be interested in actually building properties where they may not be living, and they may need people to manage these properties for them. Or as property managers yourselves, you can actually invest in building units on these islands and get concessions from the government as relates to the cost of these buildings, and you can actually have a good start in terms of rental income and income from small businesses. And as property managers, you have an opportunity to own as well as to manage. I think that's a part of it.
That's right. Thank you very much. As you're saying, as a property manager, you have some dual roles. As on your own, you can say, look, it's pretty not just expensive. There's not a lot of property in Nassau left, at least so we say, although we see a lot of empty land. But the opportunities in certain family islands are that you get concessions, so you're not paying all sorts of fees and duties and things for material and other things and taxes for building something on certain family islands. This is what it is to encourage you to build on the family islands.
Can I add to that?
Go ahead, Marjorie.
Okay, I'm just saying that in addition to what Blair just said, I think, was that Blair or Odessa? That I believe it was 2019 when there was a big surge in the Bahamas, specifically Nassau, that other persons who own properties in places like Andros, Cat Island, and all these other family islands, that they would go ahead and rejuvenate their properties, even if it's not to live on them, but to make them into something like an Airbnb or a small motel. And so the concessions, I think, were ramped up in that time. And I have a few friends who've actually gone ahead and taken that opportunity and had to engage that Family Island Development Encouragement Act.
Yes.
Mhm.
So you want to be aware of this act for yourself. You want to be aware of it for instance, sometimes you may meet a property owner who is a potential or is a client of yours and looking for opportunities for investment. And you may want to, this is the type of thing that if you're aware of it, it may be an angle to say, hey, you know what, there are these islands that for a fairly modest investment, you can get something done. And the opportunity is probably more attractive than trying to get into the New Providence rat race. Yeah, so we talked a little bit earlier about the Hawksbill Creek Agreement, which is what helps to create this area called Freeport and what they can do in Freeport. These types of agreements are very important to know about, because again, if you're a property manager, you want to know that if you have a client or yourself or tenants or whatever interested in operating in the Freeport Grand Bahama area, what are the constraints? What are the concessions? What are the things that they need to know to operate in that area? For instance, even you as a property manager may find that it's easier to set, if you want to set up a substantive property management business, in terms of having an office space and having employees and getting it all registered. The word on the street is that it's way easier to set up a substantive business in Freeport than it is in Nassau. That's the word on the street. So you may want to know that stuff. You may want to know, instead of me trying to get an office space in Nassau, I'm spending an arm and a leg, and the government approval is going to take 5 years and so forth and so on. Let me see if I don't put my headquarters in Freeport. Because there are very few fees and rental. If I have to rent a space or acquire a space, it's going to cost less and so forth and so on. So again, it's good to be aware of these types of legislation that's mentioned in the book. Okay, any comments and queries?
Yes.
Before?
The Hawksbill Creek Agreement, that's one that's always very, very interesting to me. I wanted to ask the question on that. With regard to the way that it's been renewed and all of this, and seeing the advantages, that's where I had my questions. What would be the advantage of that, besides the fact that it seems to be one large entity that has benefited from it more than the actual individual locals themselves? Like, what would be the advantage of renewing something like that for one entity?
You mean if when it comes due for renewal in 2054, why would someone renew it? Why would we renew it as a people?
Yeah, because it was renewed, just recently renewed. Well, not recently, but 2015. The same question I'm having now was raised then, and I just don't know. I think it's obviously very political, but it just keeps pushing on and on and on and on,
Well, the portion of it that was renewed in 2015 was not the overall lease. It was there's a thing about taxes. I think the lease went on for longer than 2015, but you're right. Why would we renew it? That's a subject of great debate. I don't know if we could solve that one today. Persons like myself, I'm a bit of a nationalist, believe that we need to remove it from its shackles, because it apparently is not benefiting Freeport as much as people would like for it to do. In particular, after the passing of the principals who were initially involved in the Hawksbill Creek Agreement.
Right.
Once those persons passed along, I think that the level of engagement by those not currently involved may not be there. So you're quite right. There's an argument for why do we need to keep it. An argument against removing it is that people say, you know, government doesn't do anything properly. It is kind of the accepted thing that the private person is going to do it better than government. And if the private person is doing such a bad job, when government gets their hand on it, it's going to be even worse. So those are the kind of arguments you hear.
Yeah, correct. Well, thanks for engaging me in that.
I think one of the things as it relates to that, why when the government had an opportunity to end it, is that the governments at this point, they don't have a plan. And because the Hawksbill Creek Agreement has not been perfect, it has not totally killed the island, the area of Freeport. It is still doing some good, and it's not completely broken. And because the governments just do not have a plan to say, okay, we're going to do a whole revamping of the entire Grand Bahama, and we're going to get rid of this agreement. And I think that's part of why they didn't even consider, canceling it before they actually just say, well, let's just renew it again for another every years, and then it'll be somebody else's problem to fix. I think they are well aware of the issues. They just don't have a plan, and it's like certain things that over the years, you have the same problems being repeated in all of the islands, every election, every year, every government come in. It's like, okay, they're going to be like, okay, we don't have the fortitude to actually deal with this. We don't have the plan to deal with it. So we're going to just kind of leave it and let it be somebody else's problem. And it just continuously is a continuous vicious cycle, unfortunately.
Yeah, we're kicking the can down the road.
That's the problem right there, Odessa. You just continuing to leave it, and look at us now, almost 50 years later, and still not a difference,
Yeah. So before we start looking at the prospective tenant, want to very quickly mention what's in the book. The main things that it mentions about we have the Industries Encouragement Act. And again, as a property manager, you want to be aware of what this act opens up, particularly for property owners and property managers. So this act says exactly what it says it does. It is to encourage the development of industrial properties and commercial properties. So again, it provides concessions and so forth for persons who want to develop industrial related properties. And again, when we talk later about the property manager having a unique value proposition, there's some areas in the Bahamas that are wide open for property managers or Bahamian property managers. Some of them have property managers like industrial parks. We have at least one or two industrial parks. Certainly in Nassau, there's the Airport Industrial Park. And that industrial park is managed by someone. I don't believe that someone is a Bahamian, but these types of areas are open to property managers who can put their mind to it and says, you know what, I want to manage industrial sites, manage commercial property. The guys who manage the airport, for instance, they're an international property management company. And that's how they make their money. They have their wherewithal. They can manage a project from conception to construction to operation, which is exactly what they've done with the airport. So they're managing that property and they're obviously subcontracting a lot of things to persons, but they're taking care of everything on that property, and that property is not being run by the government. It's being run by this property management company. I think they're out of Canada. Gives you an idea that there are huge opportunities in areas that involves industry and commercial, and the Industries Encouragement Act is one of those. Now, someone mentioned earlier, there is a Bahamas Vacation Plan and Time Sharing Act. Very, very important act, because the timeshare and the timeshare seems to be kind of on the wane now, but it still exists. But certainly Airbnbs are becoming the thing, or if they're not the thing already. And this act allows Bahamians and other owners to say, have a foot in the door in terms of creating timeshare spaces or Airbnb spaces. And it is apparently a lucrative avenue for persons who are interested in profitability. So you want to know with an act like that, how that allows you to get into the business. The other thing that I want to mention out of them is the City of Nassau Revitalization Act. Again, there's a huge opportunity for property managers in the city of Nassau itself, which we all know is deteriorating by leaps and bounds. The deterioration creates an opportunity for development. And at some point, someone is going to have the kahunas to say, look, and you've had people talking about it, that we want to develop stuff downtown. And one of the greatest opportunities downtown is to develop residential facilities downtown. Downtown is pretty much dead because nobody lives out there. And we hear talk of this all the time. And the great vision is, what if we can put up a whole series of high rises, townhouses, condos, and so forth downtown that attract young professionals and others to live downtown, then that will revitalize downtown. And this act speaks to allowing persons to, anything you do downtown gets concessions. Since the act has been done, a lot of people just haven't taken advantage of it. It's interesting that hasn't happened. You see construction, a lot of construction going on, but not a lot of it is going on downtown. Any comments before we go on to talking about the tenant?
I believe one of the issues with the downtown thing is the downtown properties are owned by old money. And in a lot of cases, things don't change with that until the older persons in those families die out. And then the younger persons may come in, and even sometimes what happens by the time the older folks die out, the younger people are not even here anymore and don't really care to do anything. So and unless we can get new ownership in that downtown area, it seems like it's going to take us another almost 20 years to get any real resolve to what's happening down there.
Yeah, you've brought out a very important point. And the point is that a large percentage of properties in downtown is owned by old, what we like to call old money. And you're correct. In many cases, a lot of them are no longer in existence, and their descendants own those properties. But many of those descendants are no longer even in the Bahamas. And given their inherited wealth and where they do reside, they really, I mean, the stuff that's rotting on Bay Street is nothing to them. But at the same time, they don't want to release these things because it has potential value. So they're holding on to them until their $1 million property becomes a $10 million property, and then doing nothing with it. Now, what some people argue is that given those realities, the government needs to put in place a strategy that actually forces the hand of these people who are themselves have a strategy in place. And one recommendation is that that strategy be this. Okay, if there's a property on Bay Street that's just sitting there deteriorating, that property should attract a tax of X, whatever that is, maybe $300,000 a year, some ridiculous amount, some huge amount. And if that tax is not collected, because they're not collecting tax on pretty much anything on Bay Street, they're collecting tax from you, property tax, you're getting taken from you, but no one on Bay Street is paying property tax. And then some of them have vowed they would never pay it, and they haven't. They've literally come flat out and say, we're not paying property tax. One of the things that you can do is that if you're going to raise the taxes to such a high level, and after they owe a certain amount, you say, you know what, because you owe, which we do not have that legislation in this country, do not have a legislation that if you don't pay your property tax, we can take your property.
Right, reclaim them.
So we need to get to the point where government can say, if you're not paying this property tax, we can take the property in lieu of the property tax. That's law. And once the government takes the property, and we need to have a responsible government that says, okay, these properties have been acquired, then let's sell them to people who will prove to us that they're going to do something with them. I think my opinion is that needs to be done sooner than later. And if it's done quick enough, we can probably see Bay Street turn into a place with condos and stores and, you know, just a lively, the city that it's supposed to be.
Yes, that's such a sad space right now.
Mm.
But
It is.
wouldn't that open up other loops, you know? And I thought of, as you're saying it right now, because I know this is something that's been juggled around, the same very thoughts that you're saying, Ian, about taxing the persons out there who are not using their properties at all, letting it just sit there and rot. But at the same time, I just hope that if something was to happen, it doesn't turn into the same situation where it's a matter of, you know, only the ones who have the have-nots still suffering. You know, they have their little bit of dollars, but their dollars don't go as far. You know what I mean?
Yeah, that's you're quite right, because we already seeing that. We're already seeing the fact that because Nassau is attracting premium buyers for real estate and for properties, that the regular person, I mean, even middle class people and upper middle class people cannot afford a simple piece of property in Nassau.
Yes.
And it's not because these properties are worth that. It's because we're able to attract persons with endless dollars to buy a piece of property in Nassau for all sorts of ridiculous sums. And what we're not acknowledging in many cases, one, the persons have money can't done, so they don't care what the property price is. Two, they're deliberately, they don't even want the property to be cheap. Because in many cases, these people are trying to get tax write-offs and trying to hide their money. And so they want an expensive outlet for their money. And they don't care that you're charging $1 million for a little piece of property that technically is really not $1 million. That's what they want to pay for it. But the small people are getting creamed because we can't buy a piece of property in our own country.
Exactly. And that's what that keep coming right back to that same point with downtown, you know, because like you're saying, revitalizing downtown would just be so amazing, because you notice that downtown has moved into Carmichael Road. So it's relocated. And now it's just left there to die until one major investor is going to come in, and then downtown will be foreign owned again, you know?
Yeah. because I think the residential angle to downtown is where it has to begin. It has to become a residential place, that not just Bay Street. I'm talking about the whole area between Bay Street and Shirley Street, and even creeping up the hill a bit, and changing a lot of stuff into residential stuff, and more modern city residential type things. And then the stores and the nightlife and all those things become a part of serving the residential aspect of it. Okay, so let's talk a little bit about the thing about qualifying prospective tenants. So it was a subset in the chapter, and something we're going to talk about a little bit more, because we're going to talk about things like conducting assessments and so forth and so on. But this particular thing on page 111 actually talks more about the lease agreement and how you qualify people for the lease agreement. And bearing in mind, as a property manager, where a lot of our inflows in this country in terms of high value properties are coming from persons who are paying for these things. In many instances, everything is being paid before they get here, and none of the money is coming into the country, which is another complaint. So they're making direct deposits from their international accounts to the owner in some instance. As a property manager, one of the things you're going to have to navigate, and if you're dealing with that sort of arrangement, is how do you get paid when all of this payment is being done internationally and not touching the Bahamas? Does anybody have any ideas as to how they deal with that particular conundrum?
Could you repeat that, please? Sorry.
Oh, okay. What I was saying is there are many situations, if you're dealing with high net worth individuals who own property in the Bahamas and they're renting to their associates. In many instances, what they're doing is having persons who are renting pay them where they are. So you might be renting a property for $20,000 a night. You're the property manager. You have no clue, even sometimes, how much is being rented for, because the payment is being made. Let's pick on the US. The payment is being made in the US by a US citizen to another US citizen. And they're just telling you, so-and-so is coming down with his family. They're going to be in the house for a month.
Oh, I can answer that.
Mhm.
Well, currently I have a similar situation, and even if they don't say if the client is coming and paying, like you said, they just tell you that so-and-so is coming in for X amount of nights, handle property as per usual. And then when it's time for payment, well, there's a standing, as property manager, I have a standing fee, and it's a standard fee that in excess of anything that they have done that I need to pay for, I'm reimbursed for, but they pay a wire transfer. That's how the payments are made
Okay.
from
So
American Bank to local bank.
so their US dollars is being paid to you by wire transfer. So when you get it, you're getting Bahamian dollars, obviously.
I do, and I do get a fee for that, and I pass that fee back on to them.
All right, which thank you for clarifying, because I was going to ask that question, because there are quite some substantive fees associated with being paid by someone outside the Bahamas. And you have to be cognizant of those fees and always add the fee back so that the person pays the fee.
Exactly.
All right. We spoke about the security deposit before. And of course, there's something else called an advance deposit, which is a different wording for sort of meaning the same thing. But in some cases, in especially in property management and rentals and so forth and so on, what an advance deposit does is not, I mean, some people have an advance deposit and a security deposit. So I want someone to speak to what they think the difference is.
The advance deposit might be to hold the property for a specified time as a guarantee that the tenant wants that particular date, like a fee to hold it for a particular date, especially like we may have instances where there might be peak periods. So while there's a security deposit for when you're actually there, there's an advance deposit, which is more like a hold, I think.
Wonderful. So right on the head. So that's what an advance deposit is. It is just that. This thing where you say, look, if you're really serious, you want this thing for a year from now, then advance me something so I can say to anybody else, I'm sorry, this thing is booked. And again, as a property manager, to start thinking about having that as a factor and understanding using that tool, the advance deposit, as a mechanism for your business. Some people would stipulate that advance deposit cannot be refunded, which really tells you how serious somebody is. But if you're going to do a non-refundable advance deposit, then you do have to be careful about what that amount is. Some people's advance deposit becomes a fee. In some cases, the advance deposit is simply a fee. It's not even a part of the rent. Other persons in the advance deposit is, do me an advance deposit, and whenever you come to pay your actual rent, that advance deposit gets rolled into it. So then there are numbers of strategies with an advance deposit, or that the advance deposit can get rolled into your security deposit as well. So a number of things that you can do when you talk about an advance deposit. But from an operational perspective, if someone is to pay you an advance deposit, and you've decided how you're going to use that advance deposit, you have to be careful that if it's something that you have to give back to the person, you have to have it to give back. Everybody heard that? You have to have it to give back. Then many businesses that operate where they take advance deposits from persons with the proviso that if things don't work out, I'm going to give this back to you, and things do not work out and you can't get it back. Is this, oh, it's going to take 2 months, it's going to take 3 months. It didn't take, you didn't ask me to wait 3 months to give you my advance deposit. So when it's due to me, I want it that day. There are even situations that people find with businesses, they pay an advance deposit, but they're supposed to get rolled into or get it back on the day that they actually arrive, and they can't get it back that day. People tell them, oh, it's going to take a month. So you have to be careful as a business person how you handle this advance deposit thing. Any comments? We're having a quiet day.
It seems as if, when you're dealing with the monies, the security deposits and the advance deposit, we really have to be very careful and try and put that money aside and not spend it. I mean, sometimes we have a habit of segregating or putting our monies in one pot. you know, when you have these contractually fundable funds, you have to really put them either on the mattress or on a secure account to make sure that you have it when it's time to actually pay it back. Yeah, so I think, would you advise persons to have an account just set aside for those refundable deposits?
Yeah, as a matter of fact, one of the things that you can do, we're jumping ahead and talking about accounts, but one strategy that you can do, oh boy, it's a terrible strategy the way our banks treat us, but what you can do is have different accounts for different things. So you have an account for advanced deposits. You have an account for security deposits. If you have, say, in your portfolio, a commercial property and a residential property, and say those are two things in your portfolio, you may actually want to have a different account for each of those properties, so that you can manage the inflow and track the inflow cleanly on even the outflow. So if you're paying expenses, say utilities, there's some people who go through this trouble. I don't know how you set up all these accounts in a country like ours where there's a fee on everything. But some people set up an account just to pay their utilities. So every time a utility is being paid, it's paid from account number so and so. Anytime they're importing something, they're using account so and so, and they'll transfer the money from where it needs to be transferred to the account first and paid from that account. So some people set that up, and in their mind, it's a way of somehow tracking their accounting and categorizing the accounting. I don't know if that's a wonderful strategy. I think Kevin is an accountant, so he can probably weigh in on that and tell us what his thoughts are on that strategy that some people use.
I mean, as you said, it's just all the fees involved. So if you feel comfortable absorbing the fees, then that's fine. But then again, once you have those accounts set up, and then people do set up various accounts for various activities. Anyway, I work in national insurance, and they have multiple accounts, for this purpose, that purpose, and so forth and so on, just to make sure that there's proper segregation, and also the funds are accessible and available for certain purposes. So, I mean, if you're relaxed with the fees, and you're able to justify, the fees, the bank fees, which are very, very high, then I would support, having those accounts, separated.
Yeah. And in many cases, some people are passing on fees to their clients, so they're not even caring what the fees are. But that I always looked at it and said, boy, you'd be dealing with some fees if you open up too many accounts in this country. All right, fine. Now, the thing we spoke about earlier, and I'm going to skip to it a little bit, is actually you finding a process to be acquainted with the laws of the country. I know we love being a little illegal in this country, but as a property manager, you really want to be acquainted with the laws. You will find that that's one of the ways when we talk about having a unique value proposition. One of the ways for you to sort of be head and shoulders above other persons is that you're aware of the opportunities, because one of the things that your awareness of the different legal stuff does for you is make you aware of opportunities. A lot of these precepts are actually, and it also makes you aware of barriers so that you don't get yourself in trouble without knowing. Many people are getting themselves in trouble without knowing. But that's one side. The other side is that many of these legislation actually, when you read through them, you say, there's an opportunity for me here. I go back to the one talking about ports and docks. There's an opportunity for me as a property manager to just manage ports and docks. And when I read through this legislation and I'm aware of everything that it requires for a port and dock in the Bahamas, and a port and dock, we're not talking about Potter's Key. pretty much, or the yacht haven. A port and dock could be you have a 3-bedroom Airbnb on the beach, and there's a little place where someone can pull up a boat and tie it up. That is a dock. And there's a law about what the size of that is, how far it goes into the water, and how it's built, and so forth and so on. That if you become aware of that, you can start telling people, look, there are these things that you need to know about having a port and dock, and I know those things, so let me manage your port and dock for you. And if you're in an area like a Port New Providence, and all of these are theirs, although I think Port New Providence has a property manager for the area, for the entire port. But if you're in a vicinity where people need their ports and dock managed, or you can maybe create that as a business, it might become quite a lucrative thing for you. All right, so let's, one of the things that the chapter talks about is the possibility and the potential of something called a Property Management Act. It doesn't exist. And one of the things that you in this class and other classes like this are going to have to start thinking about is understanding the other legislation that exists in the Bahamas, the Real Estate Association Act and all of the other acts, so that you can formulate a Property Management Act and take it. You don't want to go to government and says, oh, we need a Property Management Act. You literally want to go to the government and says, hey, we have written a Property Management Act. We're not lawyers, but we've written an act based on what we see that should be governing our business. And our Property Management Act is here. This is our Property Management Act. We'd like to see this enacted into law. Why? Because we want our business, the business that we're in, to be legally recognized and to be legally protected, and so forth and so on. And you hand them this thing and say, and remember, the guys who you're handing this to are always politicians, so they're always keen to please a set of constituents. So if the property managers can do this and do it soon enough, then you can get a legal basis for what you do as a profession, and it not be such an ad hoc thing that you're operating in. Any comments on that?
I think that's a very interesting point. So for something like that to happen, considering our infancy with our qualifications, and you said we wouldn't need to involve any kind of attorneys, but how would we begin the act? How would we do that? And who would be involved in something like that? Would that be anything to do with the real estate agencies or?
Well, that's a great question, because a number of real estate agencies offer property management services. But I would say this, because they do, you probably have a situation where property management is different from real estate. So you have a situation where you might be asking the fox to guard the hens. If you leave it up to the real estate people to push a separate profession, because they want to make money off the profession within their rights, and it makes sense that they would want to do that.
Yeah.
So it behoves the persons who are property managers, who don't want to be involved in buying and selling real estate as their main thing, but they really want to flesh out this property management thing. It behoves those people to actually set out the standard for how they want their profession to work and their industry to work. Some of those people are going to be real estate people. They're going to come from all walks of life. But my view, it shouldn't be driven by the real estate industry. And what you probably should do is put together a small group. I think the persons involved in massage have started doing this sort of stuff. You put together a small group, you form an association, you come up with your standards and principles, and a lot of this stuff is in this book already. And a lot of it, you have international property management groups as well. And then you codify this in a law. And this is where, this is the point where you bring a lawyer or the lawyers in and says, could you help us with this? We want to present something to the government so that they can put this into the law books. But there has to be a strategy. It's not going to get done by people wanting it to be done. It's going to get done by people having a plan on how it's going to get done. So it needs leadership, it needs structure and involvement and engagement and a time schedule, and it will get done.
Yeah, that's very, very enticing.
Yeah.
No,
So,
I agree with Ian. I don't think the real estate people route would be the best route, because they're going to look at the group as competition. While some of them will also want to become a part of the organization, but because real estate and property management almost interlinks to some degree, they're going to look at it as a threat and try and push some more of their own agendas. However, if a small group, or if a group of the certified property managers get together, and like Ian said, we start at the basic, but we also have personal friends who may be real estate agents that don't own some of the major real estate companies that may be willing to assist with finding out information as to how the real estate people got their approvals and what may be necessary to put into the documents before we engage a lawyer. And we may even have lawyer friends or relatives that may also be very valuable in assisting with the whole process. It will be really good, because at the end of the day, you don't want the people that will look at us as almost a direct competition to even put some barriers in place where it causes an issue as it relates to moving forward with that. Right.
And it's one of those natural things that you have to somehow navigate, because there are a lot of professions that sit closely held with other professions. For instance, you have doctors, but you have specialties in doctors. So you have especially in the States, you have associations of renal physicians, an association of renal physicians, but there's a general association of doctors, and again, you start to get this thing where things may become more competitive than they need to be. So you have to be careful of how you navigate that, because the people who already exist and who sometimes step into the property management arena may naturally say, hey, if these guys are going to form an official body, then they're going to be competing for work that I've been getting within my business as a real estate business. And persons are going to naturally look and say, hey, there is an official property management group, or the law recognizes property management as an industry because there's a law around it. So I'm not going to go principally to a real estate company to look for property management. I'm going to go to property management people. So that is certainly something you have to navigate, and calls for great relationship management to get it fully navigated. All right, So the rest of the chapter talks about types of leases. There are tons of types of leases. And so again, most types of leases relate to the type of property or the type of arrangement that you're going to have. So one of the things that I want to focus on out of this list is the rent to own agreement. Anybody here familiar with the rent to own agreement?
I've always heard about people saying that they're renting to own, but I never knew like the specifics surrounding it. That's something that I always wanted to learn about. Like, how does that work?
Okay. So anybody?
I'm in the same position as Blair. I've always heard about it, always thought it was very interesting. And something that I would have attempted to do as well, but never really, never got any specifics concerning it either.
Okay.
Well, as far as renting to own, some of the basic information that I'm aware of, I tried to do something similar, and the owner of the property, they were willing at the time to consider doing a rent to own, which is primarily put down a deposit that's out of, speaking of the general deposits we spoke of earlier, but this deposit was based on the rental, whatever, of the ownership. So they would tell you the value of the property and tell you how much you'd be purchasing for. So an example, let's say it's 300,000. Then you'd give a lump sum amount, and that would be held in escrow towards your purchase. So then your rent, part of the payment of your rent would go towards that deposit for your ownership. And that's negotiated based on whatever parameters that you all put in place. But I understand that there are other rent to own agreements out there, but I haven't seen any of the others besides this particular model.
Okay, interesting. There are, in the rent to own arena, all sorts of approaches. And one of the things we have to remember as human beings is that we have the power to create. So you can actually create any parameters around rent to own that you happy well want, as long as somebody agrees to it. So you can, for instance, say that from the get-go, I think Marjorie's example is an example of that. From the get-go, the rent is going to be X dollars. You're going to be leasing this place for 20 years, and 50% of what you're paying, you're actually paying towards owning it. The rest of it is rent. When you get to the 20 years, you will have the option, or we've agreed at the end of the 20 years, you're going to be able to pay the balance, and it's going to be your place at the end of 20 years. Sounds a bit like a mortgage, like you're mortgaging the place, but it's not really a mortgage because you're renting the place. The owner is not you. And the owner is responsible for the things that owners are normally responsible for. So that could be one type of arrangement. You could be renting to own with a property owner or property manager. And I'm talking about it from the perspective of the tenant, where you're renting a condo, but you can up to another condo at any point. You don't have to buy that particular condo when you're renting to own. You can say at the end of the lease period, the investment that I was making into my ownership side of it, I want another condo that you have. I mean, it's not particular this one. That could be another type of arrangement. And in some cases, the rent to own is just you're purchasing the right to own it, but you're not putting none of the money, all of the money that you're putting in is going towards the rent. And it's only guaranteeing you that at a certain point, you have the right to now start negotiating purchasing it, and it won't be sold to anybody else. So you have all sorts of ways to approach it.
I also thought, like, one of my thoughts towards it too was, you know, everyone isn't qualified to go to a bank. And similar to when I was building, like my contractor, he wanted us to go with him, and he was the architect as well. And he said, well, okay, you guys pay me this amount, and I will say to the bank that this is the deposit she came up with. So the bank looked at it as part of my deposit towards my mortgage. So in other instances, so in my mind, a part of the rent to own scenario is always also where people who cannot afford to go to the bank, they pay a substantial deposit similar to what Marjorie mentioned. And as that, and then a portion of the rent goes towards the owner, a portion goes toward, will be allocated technically toward the ownership of the home. So say in 10 years, I would have already paid the owner towards the ownership of the house, say $15,000 to $20,000. And I can then go to the bank with a document saying that I've already paid $20,000 or whatever number I said initially, $20,000 deposit to the owner, and the bank may actually use it as consideration to say, well, okay, she came up with her deposit and we will lend her the balance of the money. And that helps people who are unable to qualify for a bank loan, et cetera, something like that.
Okay, so here we're talking about how innovative you can be with this concept.
Yeah.
You can be as innovative as you like. And in this town, there are lots of persons who the bank will not lend money to, especially for a house. They lend you money for a car, but they're not going to lend you for a house. So, and in some cases, it's because of the industry some persons are working in. So you have persons who might be making a fairly decent income, but they are self-employed, or they're working in some industry that the banks somehow don't like. And you walk into the bank and say, I am making X dollars per month. And they thumb up their nose at you and says, who are you working for? And you say, I'm working, I make, I sell coconut water or whatever. I'm making $2,000 a day. They don't care. They're not going to lend you any money. So you're the type of person who can get into arrangement with somebody that says, hey, all right, technically, I am going to rent you this premises. I'm building something, going to rent it to you. But as you pay your rent, you're paying something into the ownership of it. And the bank doesn't know anything. Basically, the owner is mortgaging the place to you without a mortgage agreement, because the owner may not have a license to mortgage the place to you, or have the license to rent it to you. All right, so we're getting close to our time, and I do want to touch on the last thing, which we're probably going to have to come back to when we talk about the relationship with the tenant. And there's a whole chapter on relationships with the tenant, but the last thing talks about negotiating and the dispute resolution. A huge part of having a lease is so that if you ever run into a problem with someone, almost any problem that you could run into is covered in the lease. I'm going to say that again. In my opinion, a huge part of having a lease is that you think about what are all the things that people run into when they're having a relationship with an owner user. And you want to try and cover those things in the lease so that you don't have gray areas, because when things go wrong, everybody runs into the rabbit hole of gray areas, and that's where everybody blows things up. So you want to eliminate the gray areas. Let's talk a little bit about some of those things. And the book mentions, for instance, different interpretations. How do we avoid different interpretations? I got to pick on people in the last couple of things. Brittany, how do we avoid different interpretations? I'm not sure if Brittany is here. She said that she was 1A on the thing. Okay. Georgia, how do you think we avoid different interpretations? We're talking about a lease.
I'll give a stab at it.
Okay.
I think we can avoid that is, first of all, by getting your attorneys involved so that both persons are clear to what exactly is being stated in the lease. And if you're not sure about something, you should point out every single clause in there that you're not sure of. And even if it means getting an additional communication in terms of, okay, we spoke about clause number this, you clearly indicated that this represents whatever it is that we are agreeing to. So it just simply means that each individual is responsible enough to get clarification on everything that they're not clear on.
Great. And sometimes what you have to do is literally encourage the other party, especially if they're not prone to do it. It says, look, I need you to have your lawyer look at this. Another strategy that some people use, certainly it's one that I've used many times in my career when dealing with important and expansive contracts. At some point, you sit down, you have a face-to-face, and you literally go through every line. You do a line by line, face-to-face. You're sitting in the same room. If the person, if their lawyer is there, fine. Your lawyer is there, which is what happens a lot in these types of go-throughs. You have the legal people there, but they're not the ones who's going through it, because the persons who have to execute the contract, they want to make sure that when you read this sentence, that, okay, not only do we agree to it, we understand mutually what we're agreeing to. We're not reading it in two different ways. A meeting like that, it's so revealing. I've never been in a meeting like that with another party going through a contract where you did not run into something where you and the other party actually thought something different about something that was in the contract. So it becomes very useful to have those types of meetings. Just wanted to bring that up. So it's important for you to have a go through at the stuff in page 117. One of the things that it brings up is this thing too that we don't often think about is this personal property. If you have a relationship with someone, whether there's long-term rental, short-term rental, whatever, what standards do you have in place for if the person leaves something behind? Something could be as simple as a diamond ring to as something as big as someone has bought in a piece of machinery that they left in your place. What are the considerations here? Cohen, picking on you. I believe everybody is like falling asleep in this class today.
I'm trying to think.
I don't know. Oh,
Yeah.
I thought you asked for Cohen.
Yeah, but Blair, you can go ahead, because I'm not sure.
No, I'm trying to think first.
Okay, you're thinking.
Okay, so repeat the question again. Sorry, I thought you were asking Cohen, so I just didn't.
Yeah. So the question is this: it's about when people leave things behind, So you're a property manager and you have to have a plan for what do you do when people leave things behind. And I'm asking you, how do you plan for that? And what exactly would your plans be? So people can leave things behind as simple as cash, a ring, but it could be as complicated as a car, as complicated as a huge piece of machinery inside the building. So someone's involved in something where they bought a huge piece of machinery and they left it. If you have a unfurnished apartment and you rented it to someone and they left all their furniture and the fridge and the stove and the bed and the crib and on and on and on. It can be as vast as that. How do you strategize for that as a property manager? Just your opinions, I really want.
Well, I'll take a stab. For the most part, you make every effort to get the property. The first thing would be to get the property back to that owner, to the tenant. And failing that, you'd have, I guess, some clause, which probably should be in place. Did you leave any property behind? There'd be a time stipulation, 30 days, if that's the case. After 30 days, the property manager will, I want to say get rid of, but not use that word. They will get rid of the property will no longer be available to them. So I know that that's something that some property companies do, where they give you a timeline in which you can claim your property. So after 30 days, which is a general standard length of time, if you don't claim it, then you pretty much would lose it. But at first, the property manager would make every effort to get it to you, especially if it's something as valuable as a piece of jewelry, cash, or any such of these things.
So, okay, so when you said that they would make it,
Would that be correct in my assessing that here?
Yeah, that's fine. Everything's correct.
I have a question, Marjorie. So the property manager will make sure that the tenant gets their property, get their belongings at the expense of the tenant, correct?
Well, if that's something that you put in the agreement, I would say correct.
Okay.
Because you don't want to be out of pocket because someone left their property behind.
Exactly.
But you don't want to be out of pocket for anything.
Exactly, because the whole point is making money. You're there to make money, not to be a charity. So
you're not running the Red Cross and you're not whatever. You really are.
No.
You really have to make.
Yeah, and I'm saying that would be something that will be in that agreement, that they will realize, hey, well, I actually had $800, but I only received 500 back. Well, it cost me 300 to get you to 5 back to you, or whatever that is. But you're not supposed to be out of pocket to get somebody else's property to them. The whole point is you leave and your stuff must leave with you. And if it doesn't, you have 30 days. If not, it won't be available anymore. And
you have to place a value on your time. So as kind as it might be to return something to someone, if it's going to take some time, you are a professional. And every time that you take to do something within your profession, you should charge for it. If you're gonna discount the charge to zero, fine, but you should charge for it. And don't forget that. Odessa?
One thing I wanted to add is that this also, I feel, is where your security deposit comes into play in certain instances as it relates to this and your inspection of the property. Once the property has been inspected upon the person's leaving, that should capture a lot of things as well. And depending on what the item is that's left behind, you don't give them back their security deposit until they remove those things off of the property and out of the apartment or whatever, because at the end of the day, that is also a security for you, because some people will leave and you will not be able to catch up with them. And you're gonna have to use that security deposit to possibly have it be removed and have it be discarded. And like Marjorie said, if because I'm not even gonna hold on to nobody's car for no 30 days because I want to have my place rented off sure as soon as possible afterwards. So if it's something like a personal item and it's not collected within a certain amount of time, that is fine. But as relates to something that's a hazard that's going to cause me to not be able to rent the place and to repair the place in a timely manner, then if you don't come for that, you don't get your security deposit back. And within that short period of time, and it's not going to be 30 days, that's going to have to be resolved. If not, your security deposit will have to take care of the inconvenience that is causing me.
Yeah, I would tell you in the Bahamas, the car thing, especially on residential properties, is huge. People have their derelict car or cars that ain't working, or for whatever the reason, they find it more convenient to leave it on your property when they're leaving because they ain't going through the stress of trying to move it. It's too expensive for them, or they don't need the car, whatever. And they're gonna leave it there, and you ain't not gonna get them to move it. That's a huge problem in the Bahamas. And one of the things, because this chapter is about the lease agreement, you want to be, this is why you have to be aware of your environment and aware of your profession. You want to be able to spell out that particular possibility in your lease agreement and cover all aspects of it, so that when or if it does occur, the actual lease agreement says exactly what is going to happen and so forth and so on, and it covers you as the property manager or property owner. You want to make sure that your verbiage takes care of these things, because one of our realities is that happens a lot in this country. People leave stuff and they don't care about the security deposit, because in many instances, the security deposit can't even cover the nonsense that they're leaving. And they know it. So you have to find a way to deal with that as a security manager in the lease document. I actually know of commercial sites where the commercial renter has up and left at the end of the lease, or the lease not renewed, and they've left. They rented an unfurnished place, and they left every single piece of equipment in there. So whether they're you're talking about shelving, or whether it's computers and tables and offices and the works, they literally, the people just left, and everything they ever had in there. Some people would leave a rental property with their supplies, and I mean in their products and everything in there, giving the owner a nightmare as to getting rid of, quite a lot of stuff. All right, we'll conclude there today. I'd like to, it's close to 11:12, but so by the time you get off this call, the quiz will be available to you. I should be caught up with my delinquencies this weekend. I had a really rough week this week and fell behind. So you get your marks for your assignments, and I'll send you another assignment along with the quiz that you're doing. Any other comments, questions, or anything before we leave today? Just want to check.
Okay, so for the quiz, then once we've engaged, it will, once we've, I guess, clicked onto the link, it starts and finishes in 30 minutes.
30 minutes, yes.
Okay, so what we have from now until Tuesday.
Yeah, you have it from now until Tuesday, and it's slightly difficult. It's meant to be, but it's only on information in chapter 5.
Okay, which I'm prepared for. Okay. Have a great day, everybody.
All right, all the best to everyone.
All right, good day.
Say-